So yesterday I find out that Canaland Moors, which is a YouTube channel and group out of Canada run by Cujo or Kudlo L. I don't remember which one specifically. Anyways, he's really upset that I'm criticizing Tashreeq Bey. And he actually made a 17-minute video complaining about a number of things, mostly that I did not get into the subject matter of the paperwork let me clarify here. That I didn't get into the paperwork which was posted on Reddit. I did not find it, actually. It was posted on Reddit by Scott Comstock, and it's paperwork from Florida from... what's this guy? Yeah, there we go. Paperwork from Carmelo Etienne, which is a guy that's been posting all his troubles he's been having with the police on YouTube, which is rare because you don't usually get videos of Moors fighting with police, but thanks to this we have both the videos and the court paperwork. So that's why it's interesting here, because we actually get all the information. It's rare that we get that. That's why people are interested in the Carmelo Etienne case, and it was interesting that he started filing Tashreeq Bey paperwork. Anyways, Cujo sent some of his followers over to the channel, and some of them essentially made the similar arguments that Cujo makes. They're not sovereign citizens, the Moors are indigenous, that the United Nations Declaration of the Rights of Indigenous People grants them essentially sovereignty and immunity from state and federal laws, blah, blah, blah. So, because the main complaint on that video was that I didn't get into the... that I didn't get into the subject matter of Carmelo's paperwork. We're going to get into the subject matter here of Moors using the United Nations Declaration on the Rights of Indigenous People, because Funk Boogie, jeez, I really can't pronounce anything. Anyways, because Funk brought it up, and it's been on the to-do list. A whole bunch of people have brought it up. A whole bunch of Moors that I've been arguing with. As you can see here, it just keeps going and going. Now, as you can see here on this Moorish website, Moorish Oakland Star, Tashreeq Bey has been promoting the Declaration on the Rights of Indigenous People as a get-out-of-jail-free card for a while. This is from 2014. So let's go and see how using the Declaration on the Rights of Indigenous People has been working for Moors over the years. So, starting from newest to oldest, number one, we have LV, City of Sheboygan, Wisconsin. This is from May 28th, 2018, and we can see here that Torrance Leon Williams L. filed, quote, incomprehensible filings in his case. And as always, the L suffix means that this is a Moorish guy, and as we'll see later, he's also a sovereign citizen. As you can see here, Williams L. is suing various defendants for issuing him a citation for operating a motor vehicle without a valid license or registration. As always, keep in mind here that trying to drive without a license or registration is a sovereign citizen thing, which these guys got from white sovereign citizens. As you can see here, he says that he doesn't have to do any of that because, quote, he is a sovereign man. So keep in mind, you guys keep saying you're not sovereign citizen, but here he is calling himself sovereign. He does not fall under their jurisdiction, and he discusses financing statements, the UCC, again, another sovereign citizen, and, quote, a treaty with the Moroccan Empire. Williams Hall demands $12 million and seeks recognition as the indigenous man that I am. As the court explains, both cases are frivolous. William L's primary assertion in each is that the Sheboygan County executive and judicial branches of government lack jurisdiction over him because he is a sovereign or indigenous person. This theory of avoiding governmental oversight of one's life, known as the sovereign citizen movement, is not unique to him. So for all the guys, including Cujo, keep saying Moors are not sovereign citizens. What makes you a sovereign citizen is asserting that the government lacks jurisdiction over you because you are either sovereign or indigenous. So again, if you're saying that the government doesn't have jurisdiction over you because you're indigenous, that makes you a sovereign citizen. Moving on, he also filed a number of cases dealing with child support. Second set of cases concerns a paternity dispute, that there is a judgment for child support. This is common among Moors and sovereign citizens. That a lot of them try to avoid paying child support. Actually, let's back up because again, Cujo did say that I was avoiding subject matter here. William's argument that he doesn't need a driver's license and all the rest of the crap is bogus because as the court explains, he was in Sheboygan when he was cited with traffic tickets, quote, thus placing himself under the jurisdiction of the police department and court. Again, it doesn't matter if you're indigenous or sovereign or whatever hell you call yourself, as long as you're physically in the city or state or whatever. As long as you're physically there, you are subject to the jurisdiction. It's as simple as that. And as the court explains, other purported claims presented in each case, such as copyright violations, violation of sovereignty, violation of constitutional rights, violation of rights of indigenous people, and violations of the treaty with Morocco are all founded on the same ridiculous principles. They are all similar. They are similarly frivolous because neither case presents a non-frivolous blah blah. They will all be dismissed with prejudice. So again, all of this crap doesn't work. Similarly, with the child support case, the court explains all the problems with this. And keep in mind here, this is the type of paperwork that is promoted by Cujo and Tosh Bay and all these more sovereign citizen gurus and promoters. As explained here, the problem with this type of paperwork is, number one, Number one, federal question jurisdiction is not present here because family law matters such as parental rights and child support are solely matters of state law. So bringing a family law and child support thing into federal court will not work because those are state issues. Similarly, he says that he has the right to reclaim his human offspring because of its status, and human offspring status were not subject to the court's jurisdiction. As explained above, these allegations are frivolous, and so it is all dismissed. So, case number one, citing rights of indigenous people, LV City of Sheboygan, is a loss. Case number two is Green versus Parker from May 22nd, 2018. Keep in mind here, this was 7 days before the other case. So there are so many of these cases. And keep in mind here, Taj and Cujo do not discuss these cases. They do not show all the losses, all the people going to jail because of Moorish nonsense. Anyways, this is kind of ugly case. As you can see here, there's a parole violation. The guy tried to kill himself by running out in front of traffic on the interstate, etc. Anyways, as you can see here, he made 13th Amendment sovereign citizen claims. The complaint alleges that the plaintiff is not black and is not a citizen of the state of Tennessee. Instead, plaintiff is sovereign and is not a sovereign citizen. He says, I am simply exercising my 13th Amendment right. Rights of indigenous people are inalienable rights endowed by the Creator. The plaintiff claims that he is an indigenous, aboriginal, free, Moorish, American, sovereign national with the inalienable right at birth to a name and nationality. And then we have the usual, the claims 13th Amendment to abolish all slavery, the discussion here is that the 13th Amendment does not apply to punishment for crimes where the party has been duly convicted. Also explains that the arguments that the criminal charges are unconstitutional because the state of Tennessee has no jurisdiction over him as a sovereign are, quote, patently frivolous. These arguments raised by the plaintiff are common among those who are adherent of the sovereign citizen movement. Again, we got another Moorish sovereign citizen. I don't know how many times we have to go over this. Summary: any other claims raised in the complaint fail to state the claims upon which relief can be granted. As you can see here, these claims. All those claims will be dismissed. This dismissal is without prejudice to the plaintiff's ability to pursue habeas corpus. So basically a loss. There is there is a real issue here concerning mental health treatment, essentially he has to deal with it properly. He can't. How do I say this? Basically, he can't argue nonsense. He has to actually argue that correctly, and a lawyer would be able to help him, not some crazy Moorish guy. Anyways, next one, Johnson v. Department of Human Services. This is from Eastern District of Pennsylvania, April 27, 2018, so just a couple of weeks before the last case. As you can see here, plaintiff Maitreya Shalai Johnson. Check this out. On June 3rd, 2016, Ms. Johnson was at home when Christopher Lee and Philadelphia Police Department kidnapped her minor daughter without a warrant. She claims that she was never served with any legal documents. Her daughter was placed in foster care, where she was later abused. So basically, child custody, losing her kids. Similar situation to what Etienne is dealing with in Florida. She complains that the kids were vaccinated against her will, and then so we can see here she had a contempt situation, and she was not allowed to remain at home, and she was not allowed to visit her son's daughters. Then the kid was placed in foster care. She had another daughter. Looks like they took the new kid, and then essentially she's claiming severe physical, physical trauma, including theft of her religious property and alienation. She wants her kids back, and she also wants $150 million in damages for medical coverage for the rest of her natural lives for herself, her children, her grandson, and her partner. Number one, she's filing in form of a purse. She doesn't want to pay the filing fees. Anyways, here we go. Claims under the Declaration of Rights of the Child and Declaration of Rights of Indigenous People. This is the thing that Moors are promoting and have been promoting for several years. You can see here. Johnson also contends that the defendants violated various United Nations and international declarations, including the Declaration of Rights of the Child and the Declaration of Rights of Indigenous People. However, such declarations are generally statements of policy rather than being binding treaties. Moreover, Ms. Johnson has not explained how she believes that the defendants have violated these declarations. Accordingly, any claims brought pursuant to the declarations will be dismissed. So, problem number one, the declaration is not a binding treaty, so they can freely ignore it. Number two, none of these guys have explained how these declarations, how the government has violated these declarations. And finally, the result here is that most of the claims against all defendants except her 1983 claims against Darren are dismissed, and she has to refile the 1983 claim, basically. But at this point in the game, it's a loss. Keep in mind there, the Indigenous thing will not work. Did not work. So she has to try another angle. Next one, Clark v. United States, April 23rd, 2018. As you can hear, only a couple days before the next case. So again, there are so many of these freaking cases. Anyways, he's claiming civil rights complaint against Let's see here. Oh, okay. Apparently, he's suing one of the guys in prison. One of the prison guards for mouthing off to him, called him a Moorish American Muslim bitch who will do whatever the F I tell you to do. And also, Clark, you can't use the name Bay in our prison system. And by the way, I hear you're an ex-affiliate member of the GDs. I don't know what the GD is. I want you to know that you're going to do whatever the F I say because it's a Christian nation and we don't respect fez-wearing Muslims, and F is... that's a bad word. Okay, quick little side, quick little this. I was curious why he was in jail. Anyways, in 2004, Clark Bay was found guilty in the United States District Court for the Central District of Illinois for one count of possessing with intent to distribute more than 50 grams of cocaine base. For those who don't know, cocaine base is crack. Because of prior convictions, he was sentenced to a mandatory term of life imprisonment on direct appeal. He challenged both his conviction and life sentence. Basically, he lost here. So yeah, this guy is facing. Well, he's serving a life sentence, and he's filing. He's filing Moorish citizen paperwork from jail. Yeah, as you can see here, Tony Clark, inmate number 1407026, age 45, male, release date life. Anyways, this is the relevant part the part relevant to this video. 11th, Clark contends that unidentified officers, through unidentified conduct, violated his rights under the United Nations Universal Declaration on the Rights of Indigenous People Act. This claim will be dismissed for failure to adequately state a claim for relief under Federal Rules of Civil Procedure 8, and because the Universal Declaration does not confer private rights upon which a cause of action may be founded. And check this out. List all the people that have been trying to cite this case, the UN Declaration in court. You can see here there's Bay v. Ohio from 2011. There's Northern District of Ohio from 2011. Another Bay from New York in 2012. Another one in 2012. Another one in 2010. So again, so many people have tried this and failed. All of them have failed, by the way. But again, this is anyway. So you can see here that the case was dismissed with prejudice, which means that I can't bring it back. But again, Cujo's hero, Taj Street Bay, doesn't tell you that when he's selling you this paperwork. He doesn't tell you that it's not going to work. And yes, he does sell the paperwork, and he does ship to prisons too, as he says in his commercials. Anyways, let's moving on to the next one. Next one, Bay v. Pensauken Municipal Court from March 2018. So a couple weeks. Anyways, plaintiff Atiyah Kirkland Bay, appearing pro se, filed a complaint. She says that she was forced to have supervised visitation with her son. She was pulled over. She was given parking tickets. She wants record expunged, formal written apology. She wants $1 billion, and she essentially wants the kid back, and she wants to be on the do not. It looks like she wants to not be on the detained list. As you can see here, she cited the status, constitutional authority, federal jurisdiction, human rights, rights of indigenous people, and the Treaty of Peace and Friendship with Morocco, blah blah blah. Result dismissed without prejudice. The one good thing is that they're getting the Informa Pauperis applications granted, so hey, at least they're saving money on filing fees. So I mean, that's technically a win. Now, next one, Nolan Bay v. McPherson. I'm gonna stop at 2018. I'm not gonna go into 2017. Yeah, you guys get the pattern here. It never works. Anyways, this is Nolan Bay v. whatever. Number one, as always, we have the motion to proceed in form of Paris. These guys don't like to pay filing fees. Anyways, construing his complaint liberally, plaintiff appears to allege violations of federal and constitutional law based on the search of his automobile following a traffic stop by a Kansas Highway Patrol officer. Plaintiff contends that State of Kansas Judicial McPherson County Court is an unconstitutional private corporation not delegated to Congress. He also says that the claimant extorted fines and costs imposed under duress and coercion of a man of straw misnomer word and was improperly spelled Marks v. Nolan in all capital letters. Is clearly an artificial person, is not me, is not a consanguine relation to his Moorish family bloodline. This is in violation of claimant's secure rights, and a violation of international law, and a violation of their fiduciary oaths, and thus violating my substantive rights and the articles of Part 1 of the Rights of Indigenous People. So again, rights of Indigenous People, same thing that Todd is pushing. I mean, you can probably guess what happened here. Anyways, they granted the motion to waive the filing fees. However, the entire thing was dismissed based on futility and failure to state a claim upon which relief may be granted. So, as always, loss. Next one, January 3, Bay v. Bearing Contracting. By the way, January 3rd, 2018. Again, plaintiff Nasir Alim Bey was hired as a bricklayer for defendant, and the paperwork required for his employment. Plaintiff identified himself as a member of the Moorish nation. And on February 28, 2017, plaintiff was informed by a defendant's guard that he needed to provide additional documentation as the Moorish nation is not recognized by the United States. He met to discuss his deficient documentation and produced an allodial American national identification and an unalienable right to travel card. By the way, this is stuff that I'm not gonna say that Taj Sharif Bey sells it, but people like Taj Sharif Bey sell these ID cards and right to travel cards. Defendant was informed that this documentation was insufficient and that he required additional documentation, namely a social security number. Barry gave him a check for the value of his the hours worked. And more than notation that was for the sale of the song. Well, anyways, okay, it looks like he lost his job because he was trying to use Moorish ID. So this is a new one. Not only can the Moorish crap get you thrown in jail, but it will also cost you your job. Anyways, so we can see here, no basis for federal question jurisdiction is revealed. He inscrutably lists various sources of laws, but fails to provide any indication as to how they apply in this case. Sources of law include an administrative regulation, federal statutes, the United States Constitution, the Virginia Constitution, various articles from the United Nations, asserting a private cause of action is patently nonsensical. Moreover, the complaint fails to indicate how the Virginia Constitution, 42 U.S.C. 1983, the Federal Constitution, the United Nations Declaration of Human Rights, or the United Nations Rights of Indigenous People, I think what we're talking about today, presents a federal question. Plaintiff has failed to establish jurisdiction on a federal question theory. Anyway, conclusion. The complaint is dismissed without prejudice, so again, another loss. Finally, last one. It's getting long. Last one, Jahuda Washita of E-Terra Indians v. PHH Mortgage Corporation. This is December 2017. We're gonna stop at 2017 because I'm not going over every single case that has ever happened. Anyways, plaintiffs appear to ask for 3 remedies: land they once owned to be returned to them, land that they currently owned to be free of encumbrance, and for an injunction to perform to prevent further interference with creditors. Well, keep in mind, these are Washita Moors. This is a good find. Anyways, as you can see here, plaintiffs appear to raise 2 causes of action within these allegations. First, plaintiffs suggest that the United Nations Declaration of the Rights of Indigenous People grants them certain rights, and that defendants violated those rights by using unconstitutional foreclosure procedures and enforcing land taxation. They appear to claim that North Carolina's foreclosure procedures violate their due process rights under the 14th Amendment of the United States Constitution, because a clerk is not an elected judge presided over the foreclosure proceedings. Plaintiffs fail to state either claim they appear to raise. First, plaintiffs are not immune from property taxation or foreclosure as a result of some purported affiliation with the Washita, and it cites United States v. $7,000 U.S. currency. Quote, collecting cases and finding no international treaty grants members of the Washita Nation immunity from federal law, and criticizing claims attempting to benefit from the protection of federal and state law while simultaneously proclaiming their independence and total lack of responsibility under those same laws. Further, courts have consistently held that the United Nations Declaration of the Rights of Indigenous People does not create a federal cause of action. Yeah, again, consistently held. How can I make this clear? It doesn't work. It doesn't work. Anyways. Consequently, to the extent that plaintiffs rely on UN Declaration of Rights of Indigenous People, they do not state a claim upon which relief can be granted. Then, essentially, the due process claim is dismissed. I'll check out more. Anyway, lastly, plaintiffs request a remedy that the court cannot grant. It appears plaintiffs seek an injunction to stop current foreclosure procedures. Quote, because foreclosure proceedings are a matter of state law, this federal court cannot grant an injunction against these procedures. The court is prohibited from enjoining state foreclosure actions. Further, a federal court cannot undo the state court's foreclosure judgment. Accordingly, the motion to dismiss the case filed by the Washita is granted. The action is dismissed with prejudice, and the clerk is directed to court to close this case. In summary, every single Moor that has used the UN Declaration of the Rights of Indigenous People in 2018 has lost every single time. Of course, this is only federal cases because those are the easy ones to find. But the same applies in state courts. It doesn't work in state court. It doesn't work in federal courts. But Todd Street Bay, Cujo's hero, never tells you that. He does not tell you that the UN Declaration of the Rights of Indigenous People will not work in court. But of course, he doesn't care that it doesn't work as long as he makes money off the seminars and the donations and the paperwork. As soon as he gets paid, he's fine. He doesn't care that you end up in jail or lose your home or lose your kids.